I'm certified elder law attorney Ronnie Morton. We get a lot of questions in our office about wills. For those of you who don't know, a will is what's called a testamentary disposition of property. It's a method of saying who gets what when you die. It also allows you to say how they get it and who can be in charge of that distribution of assets. Ultimately, a will works through the execution of a will during the testator's lifetime. Essentially, that testator can state what their desire, what their will is upon their death. And so in the will, you can do things like nominate a guardian for your minor children. You can do things like create a testamentary trust for beneficiaries. So, for example, if you have beneficiaries that you wish to leave things to, but not leave them to them outright, you can create a trust in that will that will stagger out or can have some leftover control over how they use or receive that property. In a will, you get to name who's going to manage your estate when you die. We call that the executor of the estate. Executor is a fiduciary, meaning a person that acts in utmost care for the benefit of the beneficiaries of the estate. If you do a will, you're able to waive bond on the estate. Most estates have to, or most estate fiduciaries have to post bond to make sure that they faithfully execute their duties under the estate. But in a will, you have the option of asking the court to waive that bond. And in most circumstances, if you ask in the will, the court will in fact waive that bond. And most importantly, in a will, you get to say who gets what when you die. You're able to identify the recipients of your estate, and that may or may not be your offspring. It may or may not be in equal portions. You can list specific items going to specific people. You can list specific percentages or specific dollar amounts going to specific people. And they don't have to be family members, although often they certainly are. Now, one thing you need to recognize about wills is that they only operate through the probate process. A will is just a foreign document until it is actually probated in the probate estate, meaning that a chancellor has looked at it, has certified it, has recognized that it meets the requirements of a lawful will. Now, the probate process takes about 6 to 9 months in the simplest of estates and significantly longer in more complex estates, in order for it to go through the process of court oversight and court administration before the assets of the estate are ultimately distributed to the estate beneficiaries. The probate court, we call them the chancellor in Mississippi, will oversee the probate of the will, of the assets of the decedent. Now, that process is administered by a lawyer, meaning that the lawyer will file the necessary documents and take the necessary actions on behalf of the estate fiduciary, the executor, so that it can be an orderly process before the court. The cost of this is typically several $1,000s. Obviously, the more complex an estate is, the more expensive that the probate process will be. Now, a will only operates at the death of the decedent, but sometimes between the point of executing a will and the point of dying, a decedent becomes incapacitated. A will does nothing to manage the property of an incapacitated individual. A will only operates upon that individual's death. So the will does nothing to provide any kind of control during the person's incapacity. Additionally, there's no guarantee that an incapacitated individual's wishes will be followed during the period of incapacity. We have a separate process we call a conservatorship process, where a court can oversee someone's estate while they are incapacitated but prior to death. But the will itself has nothing to do with that guardianship or conservatorship process. Now, there are several alternatives to the wills. Probably the most common of those is the revocable living trust. With a revocable living trust, you can actually execute a trust as a will substitute, meaning that you can make your death distributions through the trust, but unlike a will, the trust operates outside of the probate court, meaning there won't be any oversight by a probate court. There won't be the legal requirements of probating the will, of filing for notice of creditors, and lots of other safeguards that are built into the will and the probate process. This does two things. It speeds along the process, and it almost certainly creates a much less expensive process. You may or may not need a lawyer to administer a trust, whereas the law requires you to have a lawyer to probate a will. I'm certified elder law attorney Ronnie Morton.